I'll just get that going.
Okay. So this is the continuation of the part of hearing 22 associated with the Blue Haven submissions. And the part of the process we're up to is we've heard the evidence and asked questions, and we're now in the stage of the verbal right of reply from the section 42A reporting people. This has got the additional process around it that when the panel did issue interim guidance on the strategic directions, we carved out, I suppose, for want of a better word, some of the key strategic objectives around centres and those matters. And once we hear the verbal right of reply, the next order of batting will be the panel will consider this and all the matters and revert with a minute regarding our interim guidance on those particular strategic objectives. And then there will be a process to get the formal written right of reply back from the council staff. So just checking with everyone that everyone's clear on the process. Okay, so let's just hand over to Matt. Are you leading the discussion for the 4218?
No, we have a far more important legal counsel providing guidance. So, Lauren, could you talk us through the intro?
I don't know about that, Matt, but thank you. Look, I don't have a lot to kick off with, given that the legal issues were fairly confined, and also given that I've been on leave for the past week. So what I propose to do was just outline to the panel what I understood some of the legal issues were, and then just give an indication of the fact that I intend to prepare some brief legal submissions on those. We then have a brief reply from Megan Taylor on the traffic issues. She unfortunately is unable to be here today, but I'm happy to, if it would assist, read her statement out. Alternatively, that can just be filed together with the written right of reply. We then have Tim Heath, who's also going to provide a verbal reply to the economic issues, and Mr. Bonis will wrap up with the planning reply. So if the panel's comfortable with that approach, in terms of the legal issues that I'm proposing to do brief submissions on, as I see it, the sort of primary issue that came out of the hearing was this question of whether or not the consent is likely to be implemented, and that, of course, goes to the argument of whether or not it forms part of the existing environment. So I thought it might be helpful for the panel just to give a brief summary of where the case law is on that particular issue at the moment. I then was going to have a look at the relevance of the MPS UDC and whether or not there's a legislative gap there. And then was going to have a look at just some of the case law, recent case law on retail distribution effects and how that applies in this situation. So that's the nub, I guess, of the legal issues. And if there were any others that the panel wanted me to address, I'm happy to hear that or have a discussion about that now.
Lauren, the only other thing is that we've had legal submissions from both yourself and Kate about the scope issue, so we're quite satisfied that we're on the same page, that there is broad scope, and we just have to work through these other decision-making aspects.
Yeah, I mean, look, one of the interesting things that came out at the hearing was, and I think the parties have been proceeding on the basis that the consent did constrain the scope of the submission. And certainly when you read the submission, it does reference back to the consent application and to the development. So there is, an argument to be made that anyone reading that submission would consider that what's been asked for here when it references, that they want a zone for the development, that the understanding would be that that development would be consistent with the consent that had been applied for. But I acknowledge and accept that obviously at the time the submission was lodged, the consent had not been granted. So there, to say that the consent conditions in and of themselves constrain the scope of the submission may be taking it too far.
Okay. Thank you.
And
yeah,
then,
yeah.
sorry, just one, I think Commissioner Littlejohn raised the point that if the consent's put aside, then we have the issue of the fact that we don't really have a fully formed submission, and that then raises the issue of, and it was raised in my original scope submissions, was it clear to everyone what's now being sought is what was being asked for in that submission.
Okay. Kit, was there any other legal matters you had?
No, I'll look forward to those submissions. That last point you raised, Lauren, is an interesting one, because in a way the submission was not founded on the existence of a resource consent. It was founded on an as yet unprocessed application, which was referred to as a development. So to some extent, the existence of the consent just crystallizes what the development was at the time the submission was made. And
I mean, maybe the answer is that the scope of the submission is bound by the scope of the application at the time the submission was lodged. But that would involve going back and having a look at the application documents.
Yeah. All right. Well, look, I will also be interested in your legal submissions around the issue of implementation versus given effect to, just to see whether it leads us anywhere. I was sort of slightly more comfortable with all of that sort of discussion towards the end of the hearing, but I'd be interested to see whether you had any other thoughts around whether there is a critical distinction here that we're all missing.
Yeah, cool. Okay. All right. So in terms of Megan Taylor's statement or verbal reply, it's a one-page document. So I might just read that out if that's
that sounds useful. Yes.
So obviously my name's Megan Taylor, assisting the NPDC on traffic related matters, participated in caucusing, and she says this is my verbal right of reply, which is based on the written and oral evidence presented at the hearing. She will expand on these as part of her written right of reply. She says at the hearing, the extent of the road upgrade works associated with the Blue Haven development consent were discussed. She says the proposed development will result in additional traffic in an already constrained transport network. The consent conditions for Blue Haven development identified a series of mitigation measures necessary to accommodate those transport volumes from the Blue Haven development onto the transportation network. These measures mean that the additional traffic from the Blue Haven development plus 3 years of background traffic growth can be accommodated safely by the transport network. My understanding is that once the development is fully operational in conjunction with the associated network improvements, people using the network will experience similar queue lengths and intersection delays that are experienced in the area today. Therefore, the mitigation proposed as a consequence of the consent does provide additional capacity, but it is consumed by the proposed development. I also understand that the 3 years of background traffic growth were added to recognise that the development would not be fully constructed for 3 years, and in the intervening years, traffic volumes will continue to grow. The approach of applying background growth until opening day of the development is common practice in traffic modelling and means that mitigation to the transport network is suitable once the development is operational. She concludes by saying, in summary, the road upgrade works will result in a similar experience for road users as they experience today. The consented proposal and associated mitigations to the road network do not result in additional capacity. Any suggestions that the network would be able to further absorb expansion or growth as associated with the Blue Haven submission should be treated with caution. I note that none of the transport witnesses have provided any modelling or analysis as to such.
Okay. Yeah, I think that's probably, we just have to receive that, Lauren, and clearly if I think that's certainly consistent with the evidence that we've heard from the traffic witnesses. There's nothing particularly new there.
No.
And Megan can just summarise that in the overall written right of reply and expand it as needed. So that's, if that's the gist of it, that's all fine.
Great. Okay. I'll now hand over to Mr. Heath, if he's on the line.
Yes. Afternoon, everyone. My reply sort of just covers about half a dozen little topics that were raised in the evidence by Blue Haven and in some of their responses by Blue Haven witnesses that I'd just like to touch base on to help, I suppose, provide a position, or my position, on some of those matters that were raised and discussed during the hearing. The first topic that I would like to respond to is based on I've called it the Hamilton experience. This is where Mr. Thompson and Mr. York referred to the experience of the Hamilton CBD after the base became operational, and to sort of use that as a bit of an indicative guide to the potential, I suppose, play out of effects when Blue Haven becomes operational in New Plymouth, and the effects on the New Plymouth CBD. That wasn't a new statement. They'd made those statements as part of the strategic directions hearing also. But when I went back and had a look at across both hearings, there was no actual factual data provided by either of the witnesses at either of the hearings to justify their assertions or to understand their assertions that assisted, I suppose, myself in trying to understand the basis for their position of that they don't think there was any significant effects on the Hamilton CBD. And to the contrary, Mr. Thompson, in his supplementary statement to the strategic directions hearing on 16 July 2021, he provided a table of the Hamilton CBD employment sort of over the last 20 years. And what that, and he broke it down by sectors. And in the third column, there was a sector on CBD retail employment. And when you look at that, there was a 28% decline in retail employment in the Hamilton CBD between the year 2005, which is the year the base opened, and that was, I went and confirmed that with the Shopping Centre Directory of New Zealand, which has the base opening in July 2005, and and the employment in the CBD, retail employment in the CBD in the year 2020. So what makes it more palpable is that the Hamilton's CBD retail decline of 28% occurred over the same period that retail employment across the whole city grew 26%. So in relative terms, the adverse employment impact is actually more pronounced. This suggests that the data Mr. Thompson's provided in that response in the strategic directions hearing sort of is inconsistent with the statements that Mr. York and Mr. Thompson seem to be making at this particular hearing. My position is based on the factual evidence provided in my Hearing 1 Strategic Direction Supplementary Statement, dated 16 July 2021, paragraphs 5.1 to 5.16. And I go into some detail in those paragraphs to look at some of the effects of the market view data of spending within the CBD over the period of the last 15 years when the base became operational, to show the effect of the base on the CBD in terms of retail spend. There was I think Mr. York raised a concern around my comment that I'd indicated that there was it'd been around 20 years since the base had become operational. And he suggested it was a lot shorter than that. And again, to confirm, I'm going to have a look at the New Zealand Shopping Centre Directory, and had it opened in July 2005. This means the base has been operating a total of 17 years. As such, yes, it is slightly lower than my around 20 I put in my evidence, but I remain comfortable with my statement in terms of the adverse effects of the base on the Hamilton CBD being roughly equivalent to a generation, given the decline in employment and the factual data on the retail spend I provided in my supplementary statement for strategic directions. Just one final comment on this particular topic, and it's around the appropriateness of using Hamilton as a comparable market to indicate the likely effects of Blue Haven on the New Plymouth CBD. That Hamilton has a population base of over twice that of New Plymouth, and is also experiencing a lot higher proportional growth. Hamilton grew between 2006 and 2018, which is roughly the period that the base has been in play, and I'm using those dates because there was census data that we could get. It grew 25%. So the market grew 25% on the period that the base was having most of its effect on the Hamilton CBD. Looking at the New Plymouth and moving forward over the 2023 to 2038 period, which is the period that Blue Haven will have the effect on the New Plymouth CBD, growth is only forecast to be 9% under the median projection. So it's a lower level of growth in New Plymouth, and a lower level of growth means more significant impacts on a proportional basis, and the more enduring. So you haven't got the growth to offset some of those impacts that are likely to play out, like Hamilton could do over that period.
Tim, a clarification for me, when you're talking about growth, you talked in that last bit both about retail growth and population growth. What are we dealing with?
Sorry, I was talking about population growth.
Population growth.
Yeah.
So what were the numbers? 2006 to 2018, Hamilton had
25% growth. And the median projection for New Plymouth over the 2023 to 2038 period is estimated at 9% at the moment.
Okay, got that. Thank you.
Yep. The second topic I'd like to respond to is based on the retail modelling. At the hearing, Mr. Thompson repeatedly stated, both in evidence and in some verbal responses to the commissioners, that I have not undertaken any robust retail modelling of the New Plymouth market, nor assessed vacant retail capacity to form a reliable position, Blue Haven. What I'd like to suggest there is that comment appears to not recognise all the cumulative modelling I've done over the last 6 years on the New Plymouth market. I've done modelling of retail, office, industrial and residential markets in the order of about 8 models for that and upgrades, of which 3 were specifically for retail modelling of the New Plymouth market and updates over that period as new growth projections came out. So I'd suggest, to purport I've not undertaken the necessary retail modelling to form a position, I'd suggest it's factually incorrect. And I'd strongly reject that I've not done retail modelling of the New Plymouth market to form a view on Blue Haven. Mr. Thompson concludes impacts on the city centre are less than minor. He reached his conclusion with him estimating $105 million impact or a trade diversion from the city centre for a circa 40,000 square metre consented retail development, Blue Haven. It would appear, based on that conclusion, that Mr. Thompson considers the current state or economic metrics of the city centre less the 105 million. My estimate was 120 million, so we weren't too far in that regard, would result in adverse effects of less than minor. When you looked at the 2021 metrics for the New Plymouth CBD, which is the initial, I suppose, post-COVID data that we have, it shows a significant level of weaker metrics across the New Plymouth city centre. And this appears not to have been considered by Mr. Thompson. If you look at these weaker current metrics and then remove the 105 to 120 million we both estimate would come out of the CBD, I struggle to reconcile how you can reach a conclusion that is less than minor. I also noted that Mr. Thompson changed his less than minor conclusion to insignificant in an answer to Commissioner Littlejohn. Insignificant, in my understanding, is even less of an impact than less than minor. Insignificant, as I interpret, means no discernible effect, small or not noticeable. Even using Mr. Thompson's own impact figures of taking 105 million out of the city centre, it is implausible, in my view, to reach a conclusion it would have no discernible or noticeable effect on the New Plymouth city centre. Furthermore, the impact determined by Mr. Thompson is just the starting point. His estimate is of direct trade impact on a consent baseline only. This excludes any consideration of the losses of important economic attributes of centres and the agglomeration of activity, and in particular the city centre, as outlined in my Hearing 1 Strategic Direction Supplementary Statement, paragraphs 4.1 to 4.46, where I talk about some of the economic benefits of agglomeration of centre and commercial activity. So what I'm saying there is that Mr. Thompson has assessed only the direct trade impact, but not the flow-on consequential adverse impacts as a result of that. What became apparent during the hearing was that Blue Haven do not want to be constrained by the consent. They seek flexibility so they can develop something else under a new special purpose sub-regional centre zone. Blue Haven could not define what this something else was, what it would look like, nor its extent. In effect, this means Blue Haven are seeking a rezoning from general industrial zone to a special purpose sub-regional zone for a new centre that would likely be different from the centre that they have consent for. A special purpose sub-regional zone could produce significantly more retail on the site than the consent, which would result in a direct trade impact a lot higher than what I or Mr. Thompson have outlined in our respective statements. Excuse me. There is no economic evidence before the panel to suggest that more than the consent is appropriate, or a rezoning of the subject land to special purpose sub-regional zone centre is appropriate. My position is that if the consent is fully implemented, it will cause significant adverse retail distribution effects on the New Plymouth City Centre. Therefore, anything more, as the submitter seeks, can only be worse. And by more than that, which would just add to the further add to the adverse effects and push back the CBD's recovery beyond the decade I'd outlined in my statement.
Tim, just interposing here. So you're at the significant retail distribution effects end of the effect spectrum.
Correct.
And you're saying that Adam got to less than 1 and then insignificant effects, which I suppose just reconfirms the totally opposite economic evidence on this.
Yeah, I've got a reply to I think it was actually your question, Commissioner, during the hearing on what's driving some of those differences, to hopefully provide a bit more clarity on why we've ended up in quite different places.
Okay. You'll come to that.
I'll come to that. Yeah.
But are you still on the retail modelling topic?
Yes, I am.
Okay, I'll let you carry on. I do have a question about the gravity modelling, whether you've done that and how significant it is that you have or haven't. So that's
okay. Yep. I'll get to the end, and I'll just pause at the end.
Okay.
Fundamentally, when assessing retail impact analysis under the RMA is not just a direct trade impacts that are relevant. It also impacts on amenity and vitality. This requires evaluated judgment. Without doubt, any further reduction on the 50% decline in pedestrian counts experienced over recent years, I know Mr. Thompson produced no counter evidence on this point, would result in further degradation in amenity and vitality in the CBD. Mr. Thompson does not appear to be applying the correct retail impact tests under the RMA, in my view. Mr. Thompson queries whether my economic analysis should have been framed by the strategic directions of the PDP. He stated the economic analysis cannot be framed by these planning theories. Despite Mr. Thompson's misgivings, it is entirely appropriate and indeed critical, in my view, to frame the economic impact analysis of Blue Haven in the context of the strategic directions in the PDP, which also in line with the RPS and the RMA. The strategic directions represent the will or desire of the community. They cannot be dismissed, as Mr. Thompson appears to do in his economic analysis, as theory. Without applying the appropriate district plan and RMA framework, the application of a generic retail gravity model without any local context evaluation will be at odds with the actual environment, including its regulatory framework, meant to be assessed. As such, I maintain that my economic analysis is appropriate and adopts the correct economic basis and framework to assess the impacts of the Blue Haven consent. Mr. Thompson stated that the retail model was best practice and referred to it as commonly accepted. Unfortunately, he provided no evidence to say commonly accepted by whom or where. Without such a statement, it's simply unconstructive. The gravity model was developed mid-last century and is derived upon a raft of mathematical calculations that require layers of assumptions just to generate an output. It was not developed for the RMA context, and without some visibility of the black box and its tabular inputs, it is impossible to gauge how robust the inputs and assumptions used actually are. Furthermore, the application and reliability of the outputs of these mathematical calculations in the context of the RMA does not represent the full suite of adverse effects, as only trade effects are derived. In my view, unless a practical evaluative judgment is also undertaken with respect to the gravity model outputs, so as to ground truth results and interpret them in the context of the local market and local planning framework, the outputs of the model will have limited value. As an example, Mr. Thompson has not considered all the non-trade flow-on adverse effects on the benefits of retail consolidation as outlined in my supplementary statement identified earlier. As a result, I do not consider the conclusions Mr. Thompson reaches are reliable or credible, nor do they represent the suite of adverse effects as a result of either the Blue Haven consent or the sought special purpose sub-regional zone under the RMA. As an example, under Mr. Thompson's modelling, Blue Haven's 40,000 square metre circa consent results in insignificant impacts. If that is the case, then a legitimate query is how big a development is required in Mr. Thompson's gravity model for a significant impact to be reached. 100,000 square metre plus, maybe. What Mr. Thompson's gravity model output suggests is Blue Haven would have to build the largest regional mall in New Zealand, circa the size of Sylvia Park, which is around 106,000 square metres GFA, before his gravity model would likely indicate significant effects on the New Plymouth city centre. In my view, this is untenable. In response to questioning from the panel, Mr. Thompson confirmed his impacts table was incorrect and had inaccurate totals. He has now produced another impact table in the summary statement with new numbers with up to $250 million difference in his analysis or conclusions, and yet his analysis and his conclusions did not change. I find it difficult to reconcile how such a large change in market numbers could result in no impact on his conclusions and question the rigor, reliability and credibility of the impacts tables in the model outputs. Finally, I know Mr. Thompson assesses Blue Haven's impact against the 2023 year. It is not clear why Mr. Thompson relies on using 2023 as a base year for impacts when he determines 2026 is the likely year of Blue Haven's opening. The more appropriate approach is to quantify the pure direct sale impacts in an assessed year on a with and without basis. Applying an early year incorrectly reduces the trade impacts. As an example, if you compared to a 2018 base year in Mr. Thompson's table, Blue Haven would have no trade impacts at all on the city centre. It's an unscientific way of evaporating away direct trade impacts. I consider it inappropriate as it masks the extent of direct impacts. I consider it, Mr. Thompson's own figures estimate 105 million trade impact on this New Plymouth CBD in 2026. His statement of only 28 million impact in the city centre under questioning from the commissioners was based on comparing against a 2023 baseline instead of 2026. Again, I question the reliability and credibility of Mr. Thompson's conclusions. So that was all I had to say on the retail modelling. If there's any further questions, Commissioner.
I'll see whether Kit has anything, but I do have certainly a couple of questions.
Sure.
Yeah, thanks, Mr. Heath. Only one. I mean, I'm not in the frame of mind to get into the essence of all of the criticisms between you economists, at least not in the current position I'm in.
Yeah.
One question I did want to ask you though was just to I guess clarify the way in which the proposed zone, call it whatever it is called, is currently constructed, is that it would have I guess a permitted GFA threshold for certain types of activity. And I understand that there's a general agreement as to which ones ought to be capped as permitted and those that ought not. Is that, I'm still remembering things correctly?
Yeah. My particular concern was around retail activity, office activity, and I think some visitor accommodation. Yeah.
So, and the way I understood it's constructed is that if there was a proposal to go beyond that, which would in effect would be asking to develop more of the, let's just for the sake of argument call it adverse retail. If the centre was going to want to develop more adverse retail, then it would have to go through a consenting process to do that. And so it's not really right to say that they're asking for carte blanche, is it?
Well, my response would be it now has a sub-regional centre zone.
Well, not
And
yet,
when
it doesn't.
Under that potential scenario, which in my view sends a signal to the market that that's where council find it acceptable for those activities to go.
But surely you could craft the zone in a way that once the adverse retail was established at the proposed GFA, there was a clear signal within the zone provisions that that was it. That was the end of it. You could make it non-complying, couldn't you, to develop any further adverse retail?
Yeah, I it's probably a question for Mr. Bonis, but
yeah,
I think it would certainly help my level of comfort if something that firm could be achieved.
The other aspect of it, which is what I was going to ask you about, the Blue Haven provisions have suggested that to provide for more retail, it was actually constructed as a restricted discretionary activity, and there were some assessment criteria, and there was one criterion in particular which I talked to Mr. Thompson about. And I don't have the wording in front of me, but it was along the lines of whether or not the additional floor area would have an impact on the vitality and vibrancy of the city centre. Do you remember what I'm talking about? There's a
above the consent.
Yeah, there's an assessment criterion for an application to exceed the permitted threshold of adverse retail. So if they wanted to develop more, need a resource consent, there was an assessment criterion which was quite evaluative in looking at the impacts of that additional area on the vibrancy. And I guess the question I wanted to sort of push back to you was, if we were not satisfied that that criterion was actually measurable or able to be, scientifically determined as to an effect level, what would your suggestion be? I mean, I'm bearing in mind your first answer is you wouldn't want it to have any sort of evaluation whatsoever because you just wouldn't want it to happen. But if in this thought experiment we're having here, we wanted a criterion that would enable an application for additional adverse retail to actually be properly assessed in terms of its effects on the CBD at that time, what sort of craftsmanship or wordmanship would we need to put around a criterion to achieve that, do you think? Or is it even feasible?
Yeah, it is quite tricky, but I think you'd really want words that express the level of sales and pedestrian employment and amenity and vitality, really, because they're sort of metrics you can assess and make an estimate of what the effects would be. Yes, it is a question for the hand it over to Mr. Bonis. But yeah, you have to be very careful because, I mean, Mr. Thompson's model already says not an issue with more, and not an issue with quite a lot more based on his modeling. So it has to be very carefully worded to ensure that you can actually put a cap on it. I'm just trying to think through my experience. When you have a sub-regional zone, it sort of sends a signal that that's the location where the Royal Council support that type of development. So it'll be difficult to kick for touch on economic grounds, probably.
Yeah, okay. All right. No, thanks for that. Yeah, I understand.
Yeah, thanks, Kit. I think that's a very interesting line of questioning because we've been going at going at this for sort of a year since the strategic directions.
Yeah.
We've set up a special process with witness conferencing to try and get the type of analysis that we need as decision makers in terms of retail distribution effects, and the two economic participants in this are miles apart. So
Yeah. It's frustrating.
Thinking ahead, if there was such a criteria around, any additional over and above the consent GFA or what's being put in the zone at the moment, how, and if that was a critical assessment criteria, how would you frame that? Because there seems to be, to let decision makers have the right advice, because at the moment we have no clarity apart from our own evaluation of the two competing economic positions.
Yeah, it is. I think difficult economically, because a sub-regional zone really sets a new baseline and a new framework in which to undertake the impact assessment. Even though there might be some thresholds where you can do some checks and balances, it is a zone that does, my understanding, that provide a location for those types of activities which they were trying to seek as being additional, whether they're adverse retail or office and things like that. So it would be very difficult to wordsmith some provisions that would really be able to keep those checks and balances with meaningful bite, in my experience. Okay,
so it comes back to what Matt and the team say from a planning point of view on those questions. But there's no point harping on anymore about the divergence of economic opinion on this matter. We did flirt with the idea of perhaps having a peer review, but we've moved past that. Right. So you're on to another topic?
Or just I'd like to make one point on the joint economic conference, and Mr. Thompson made the remark in response to Commissioner Littlejohn, or a question from Commissioner Littlejohn. He said that the gravity model was discussed during our economic joint witness conferencing. For the record, that is factually incorrect. I cannot recall having any discussion about retail gravity modeling, or that we would prepare a retail gravity model during the joint witness conferencing. And the joint witness statement contains no reference to any discussion being recorded. So I would have made my position very clear if we had discussed the merits of the gravity model, because I don't think it's a valuable or reliable tool in this instance, and I certainly wouldn't promote it. So I thought I'd just wanted to make that point in response, that it wasn't discussed at our joint witness conferencing.
But Tim, I think I read out one of the statements in that joint witness statement at the hearing, which did indicate that further economic assessment, if there was time, would be beneficial. Can you recall that? It was...
No, I can't, sorry, Commissioner, but I was just referring to in that comment that Mr. Thompson, in his response, indicated that we had discussed the gravity model in particular during the conferencing, and that simply didn't occur.
Okay, but you're not, we can go back and look at the joint witness statement, because there is an agreement that further work on retail modelling and effects would be beneficial if there was time, something to that effect.
Yes, yeah, but that's not in terms of utilising the gravity model to undertake that work.
I understand that you're separating that out, but my question at the hearing and the question now is why Mr. Thompson's gone off and done that gravity model to presumably bring us some more evidence in his view. What could or should have been done between the joint witness statement and now that could assist us any further?
Well, the main point I'd suggest is, I think Commissioner Littlejohn mentioned it, is to lift bonnet and let's see what assumptions and tabular work has gone into developing the retail gravity model that Mr. Thompson's utilised, because no one has seen those tables or assumptions as yet, and that may help identify areas of difference and some refinement that could actually provide some more, or I suppose, bring the economic work closer together.
Okay, but again, at the hearing, there was no, between the time that the gravity model came through from Mr. Thompson, there hadn't been any sort of trying to get together to work out what's under the hood between you, was there?
No, there was no discussion post the joint witness conferencing on the gravity model assumptions or the layers that he's adopted.
Yes.
Yeah.
But you'd accept, I think, that we've got one economist who's done this gravity model,
Yep.
was leading to his expert opinion to us that that work leads to an insignificant effect regime
Yep.
on the current CBD.
Yep.
And you're at a significant level.
Yep.
What do you say to us about,
Mm.
and I made a comment at the hearing, I know at the end that, you know, there seemed to me to have been ample time to get together and lift the hood if that was really important. Coming to the
No,
end.
I'd agree with that.
Yes.
Mm.
So do you think we should be directing that?
Well, I think if you wanted to get made perhaps greater clarity on the veracity of the model and some of its assumptions and understand what's gone into it, the gravity model, and I think doing that would actually bring the economic outputs probably closer together, or at least even then better understand what's driving those differences. Perhaps that process would help that. I'm not going to say we're going to be singing and dancing from the same page, but at the end of it, but it could bring the work closer together and provide a greater understanding of those differences. Because at the moment we simply don't know.
Okay, well, look, I do want to come back to the to council for both the council and Blue Haven on, you know, timing and where we're heading with things. But I think I got to the stage that council, when you sort of had your chance to open some dialogue without direction, and then we are running out of time. So
yes, yeah.
Well, look, let's just leave it there, and we'll come back to that towards the end when we wrap up.
Yeah. All right. Probably it's a good segue into this next little section of some of the differences, but you know, in the gulf between the economic outputs between myself and Mr. Thompson. The first key difference is that Mr. Thompson did not utilize the most up-to-date 2021 data points. He relies on the pre-COVID 2020 data, which in my view, he misses a lot of the actual initial impacts from COVID and misses what are some of the adverse effects that have happened between the 220 and 221 years. And this is important because the retail employment base of the city centre took a significant hit in the initial COVID year, and that's not going to recover anytime soon. In essence, by taking the 2020 starting point, Mr. Thompson is really not at the correct start line for his gravity modelling approach. His data is too high, and if you're not at the right start line, in my view, you can't expect to reach the right finish line. Another difference, Mr. Thompson considers the economy will bounce back from COVID 2 months after the international borders open. I think he said in one of the responses, and I do not. He has provided no evidence to support such an opinion, and from the material and analysis that I'm aware of, Mr. Thompson would appear to be quite alone in subscribing to that position. To contextualise Mr. Thompson's 2-month assertion, it took most territorial authorities around New Zealand that I analysed at least 7 to 8 years to get back to the pre-global financial crisis 2008 employment levels at a district level. So at a district level, it took just less than a decade to get back to previous employment levels. Some territorial authorities are still trying to get there, So that's another point of difference. Another reason Mr. Thompson's 2-month theory is unrealistic is that all the pre-COVID airlines that flew to New Zealand are not flying back to New Zealand straight away. Some airlines have signaled they'll come back with lower numbers of flights initially in later 2022, but many are not coming back to 2023. There are a multitude of other basic macroeconomic reasons why Mr. Thompson's 2-month assertion is untenable. Supply side constraints, GDP falling, interest rates, high inflation, capital, liquidity in the market, etc., all pointing to a slower economic recovery for the country. There is no need to go into these in any more detail, but just suffice to say, I do not consider Mr. Thompson's assertion as factually plausible or based on solid economic foundation. And that's the assertion that will bounce back within 2 months. The final key reason for the difference between Mr. Thompson and myself is the growth projections.
Mr. Heath,
Oh,
can I'm just interested in this because, of course, when the plan was under construction and was being notified, and all of the zones were preparing, we were living in that idyllic Garden of Eden, which didn't involve COVID.
Correct.
And it sort of draws into question to what extent we ought to be designing a plan that is, I guess, modifying itself along the way to deal with macro global events. I mean, it just seems, yeah. Look, I don't have a particular view on it, but it just seems a little bit critical of Mr. Thompson to say that he should be looking at the world through COVID eyes, when in reality the plan's almost got to rise above all of that stuff and put in place a framework that's going to be able to cope regardless of those sorts of things, isn't it?
Yeah, well, my response or my comments to Mr. Thompson were he had indicated that he thought that the market and the economy could bounce back within the 2-month period of the borders opening. I just don't think that's plausible. But you're right in terms of, in the district plan process, and it's timing, isn't it? The timing of the district plan process has not been great in terms of COVID. I mean, if I was to define the core area of the city centre today, it would probably be slightly less than what I defined pre-COVID, as a result of the impacts and the more subdued growth projections, not only for New Plymouth, but for a lot of areas around the country. Do we need to rise above that? Yes, but I don't think we can pretend to ignore that and not acknowledge that growth is likely to be lower and slower than what the original anticipation was at the start of the PDP process. As long as we don't have to, the way I view the plan is we're not having to pick a specific course or a growth profile or a trajectory. I'd like to think that the PDP is setting up provisions that does provide the flexibility that if growth occurred at a faster rate than what was anticipated when the plan was developed, it could accommodate that with a set of provisions that enable that to occur. So it provides flexibility moving forward, because what we all know is no one actually knows the growth trajectory any area is going to take. It's all going to move up and down over a period of time. But as long as we have, I think, good, robust guidance in the provisions that have inbuilt flexibility to accommodate growth when it occurs at a faster or slower rate, then I've got a level of comfort around that, I suspect.
Well, I think that's where I've sort of got to as well, is we've got some longer term trends that there is a difference between you and Mr. Thompson on how significant they are in terms of the existing structure of the CBD. On top of that, we've got this global pandemic that's really knocked it for a six, like it's knocked everywhere for a six, and has really reduced its resilience to bigger change. In the middle of that, we've got a proposal that got consent, which is for whatever we sort of number we put on is going to have some form of impact on the CBD as well.
Yeah.
And to some extent, what we're debating about is exactly the same thing. It's about those provisions that enable more to happen or less? And what's the sort of the baseline that you measure the effect of additional impacts on the CBD, for example, which really comes down to what's the threshold for that for consideration of those additional potential retail impacts beyond the baseline that the Blue Haven consent sets, which is sort of that same discussion we were having really about how do you set up a set of provisions that are going to enable the existing situation with all of its broken and pandemic outcomes. How do you enable that to be assessed against an additional proposal for retail out at Blue Haven?
Yeah,
So
and
quite a complex task, isn't it?
Yeah, the line in the sand. Once the consent, or if the consent is developed as consented, the development is developed to the consented level, the baseline moves up in terms of the impact baseline.
Yeah.
So the effects of Blue Haven that are going to have in the CBD just almost sort of go under the covers, and then anything more is it's going to have to be quite a bit more to be significant again to reach the significant threshold. So it doesn't. I mean, there is an cumulative effects type proposition, which you could look at it. But it's the general state and house of the CBD at the time of the consent is made, as an application is made.
I think that's right. That's the best we can do, I think.
Yeah.
All right. No, thanks for that.
Okay. Just trying to see where I got up to, sorry. Oh, the final reason for one of the differences between Mr. Thompson and myself is the growth projections. Mr. Thompson relies on extrapolating a growth level over a recent 3 to 4 year period, which was high growth, and then continues that trajectory over the next 17 years to 2038. In my view, Mr. Thompson, in effect, is extrapolating a continual boom. And that's a fairly basic extrapolation technique, but it does not represent a professional projection in my view. Stats New Zealand, on the other hand, who I have, and most New Zealand local authorities have relied on, excuse me, are an organisation mandated by the government to undertake professional projections. They undertake a thorough process and incorporate a wide sweep of data for their projections, including future fertility, mortality, migration, ethnic mobility, living arrangements, labour force participation rates, all affecting the patterns of population. I consider the Stats New Zealand projections represent a more reliable and thorough set of projections compared to Mr. Thompson's. And I'll just note there, even since I've done my modelling, there's been another wave of an updated growth projections, and these are even lower than the ones I took for my modelling of the PDP. So this would indicate that, particularly over the formative years, the growth projections are going to track lower than what I'd modelled and significantly lower than what Mr. Thompson has assumed with his trajectory. And to put that into context, the current medium average annual household growth over the period 2023 to 2038 is around 215 households annually. And Mr. Thompson's, this is less than half Mr. Thompson's projected 560 households annually. So I'm just indicating you've got to be cautious. Yes, there's going to be ups and downs along the period, but when you just project off a high, you've got to be very careful, because doing that over a period of time, you can actually end up with some very big numbers in terms of retail market size and things like that, which I don't think is realistic. The fifth point, and second to last point I just wanted to respond to was Mr. Thompson stated my recommendation was to reduce the size of the CBD by 54%. And that is not correct. The CBD will not change in size. The PDP identifies a consolidated city centre core area within the wider CBD area with a more enabling set of provisions to encourage investment and development in the focused area. This is designed to elevate the competitiveness of the core area relative to other business locations in New Plymouth. And I think that's sort of partly what you're talking about, Commissioner Littlejohn before in relating to having some of that flexibility in the provisions to enable that development and thrust to occur in the CBD core when it occurs. The PDP is more appropriately managing where retail and commercial development occurs, not restricting or stopping competition. As espoused by, I've been quite firm on that position for a number of years now, that the RMA is actually an enabling effects-based document. It doesn't, and you shouldn't have policies that try and undermine competition or restrict development. My ethos, so underlying ethos, has been, it's about managing where that growth net development goes and assessing that in terms of whether that provides a net benefit to the community or a net disbenefit to the community, and understanding the scale of that. So I'm all for new development that results in a net benefit to the community. In my view, this is consistent with the economic efficiency and effectiveness of the RMA, a fundamental concept of the RMA. However, applying Mr. Thompson's inflated demand figures would come nowhere near sustaining the existing CBD area, which is another reason why residential activities are also being promoted as a land use to more efficiently utilise the CBD land resource. So retail and office commercial development by itself isn't going to fill the wider CBD for New Plymouth. Just my last point, I just wanted to talk about pedestrian counts. Mr. Thompson stated lower pedestrian counts have emotional value and not analytical value. Now, there's a bit of conjecture whether he said emotional or notional. I wasn't too sure. I heard emotional, but it could have been notional. But either way, but he concludes that they're not important. So again, I would suggest Mr. Thompson would be quite alone in that view, that pedestrian counts are not important to a centre. It certainly is not the view espoused by economists, town centre retail groups, corporate centre owners, and indeed individual retailers themselves. Frankly, such a statement is staggering for a retail expert to make in the context of the New Plymouth CBD. I have no idea, excuse me, I have no idea how Mr. Thompson evaluates emotional or notional value in the statement, as he produces no evidence on it, or how he's quantified it and how it relates to the New Plymouth CBD. And importantly, how it relates to impacts and effects. Simply put, it appears Mr. Thompson, when confronted with a factually and empirically obtained metric of CBD decline, has simply sought to identify such as fake news to be disregarded. Pedestrian counts are a direct measure of vibrancy and vitality, noting that such a metric is achieved within CCZ 03. Furthermore, Mr. Thompson agreed pedestrian counts were an important attribute for assessing centre impacts and performance under the Economic Joint Witness Statement. I cannot reconcile his position under questioning from the panel. So in summary, in my view, Mr. Thompson has produced no economic evidence to counter the facts or the economic metrics in my evidence, 2021 employment count data, pedestrian count data, and growth data. So on that basis, a large proportion of my evidence remains unchallenged, and I maintain the evidence and conclusions I have reached. And I'm happy to answer any further questions you may have.
Kit, do you have anything else?
No, that's good. I look forward to seeing that in writing so I can study it a little bit more. Thanks, Tim.
Yep, thank you.
Yes, and no further questions from me. I do want to come back to the council at the end about if there's any, given the obvious strong disagreements in terms of the economic evidence, whether there's any merit or usefulness in proceeding with any further discussions between the two economists. Lauren and Kate, I'll do that right at the end after we hear from Matt and the planners. Thank you.
Thank you.
Good afternoon, panel and experts in legal counsel. I'm in a similar position to Mr. Heath. I've got quite a dense set of notes that I'd like to get through. And I'm just wondering whether or not, with the panel's advice, now may be an opportune time to fill up with coffee and Panadol. I'll try and make things as brief as I can, but there's still quite a bit to get through.
Okay, let's do a 10-minute break. Come back at 3:25.
Thank you, sir. I do appreciate that.
Okay, where you go, Matt?
Good afternoon. Right, so just in terms of a roadmap, and again, I will try and be as concise as I possibly can, but it is quite dense. There's a bit to get through. Essentially, I've got a very brief overview. I was asked some questions around the weight to be provided to the non-statutory documents. Briefly cover off the NPSUD policy. There was some useful discussion between Commissioner Littlejohn and Mr. Batchelor, especially between policy 1 and 6C, and I've tried to delve my mind into that as well, and also objective 3. And I think that sort of brings to focus the economic question, I guess, that's in front of us all, and especially the panel, between the two economic witnesses. And there's two questions. It's not just one of significance in the use of the gravity model. There's also this broader question as to development capacity and the contribution or otherwise of the Blue Haven site to that development capacity, and whether or not, as a consequence, and of all the other matters that need to be taken into account, whether or not as a whole the urban environment represented by New Plymouth, the urban area, performs as a well-functioning urban environment. So there's a bit in there to tease through. UFD 18, strategic directions. This is this allocation versus protection element that I raised at the hearing. There's also this hierarchy versus network of centres issue, and the reasonably practicable options. And lastly, second to lastly, is the issue around, is the consent likely to be implemented, codifying the consent, and lastly, tangata whenua issues. So I'll whip through those. Please stop me at any point if I'm going too quickly, or if there's points of clarification that are required. So in terms of an overview, the task or the tests before the panel are actually fairly straightforward. The complexity that's actually involved, and it's one that obviously confronted the planners through the joint witness statement process, was the applicability of the existing resource consent within that framework. And there's consequential matters that flow out of that in terms of the provision sets that are recommended between myself and Mr. Brophy. And also I'd suggest some evaluation exercises in front of the panel as to what do those provisions then enable or provide for, where are they set, and there's some section 32 AA questions that arise from those, specifically in terms of the divergence of views that you have between the economists. I would suggest that in terms of design and also transport, the railway tracks are pretty clear, pretty obvious, and those matters are largely resolved. In essence, the legal framework is set out by sections 32 and 75.3 of the RMA. This is known, obviously, to the panel, but it involves whether the proposed provisions will achieve and or better meet the purpose of the RMA, or the settled objectives of the proposed district plan, as obviously subject to submissions and the breadth and width of those submissions than the existing provisions. Now, this is important in terms of the discussion, and I think the interim guidance that the panel provided in terms of strategic directions, and I think what I understand to be the next step. My understanding is that there's no ambiguity at all as to the overall thrust of the centres-based provisions at UFD 16, UFD 17, UFD 18, and the Central City Zone Objective 1. Essentially setting up the centres process, provisions, and the importance around those, and also sort of the implications in terms of taking on the distributional effects from non-centre locations. Any conclusion by the panel that the extent of the amending proposal results in adverse distributional effects detrimental to the role, function, or vibrancy of the central city, in my view, weighs against the amending proposal and subsequent provisions and the way that those are codified being the more appropriate. Now, I'd suggest that that policy direction is not subject to challenge within the scope of the Blue Haven submissions. The Blue Haven submissions on those matters really are on UFD 13.8 about ensuring that the district's business needs are met, and of UFD 16 and 17 in terms of interchanging hierarchy and network, although for the latter, they talk about the central city retail role being more boutique. I haven't seen any evidence on that. And also UFD 18, interchanging hierarchy to network. Apart from those words changing, there really isn't any challenge that I can see to the thrust of those provisions, the importance of centres, and whether or not you explain them as a hierarchy or a network, but then effectively go through and identify what the role and function is, which sets up a hierarchy. I think that policy thrust and those objectives is largely settled for the panel in terms of making a determination under section 32(1)(a). So the test for the panel and the complexity of the resource consent is in between the proposed plan and the GIS and the amending proposal for a sub-regional centre. What is the more appropriate in terms of achieving those actual objectives? There isn't a need to read up, I would suggest, massively in terms of the Resource Management Act. So that's the overview. Hopefully I'll speed up. In terms of non-statutory documents, Commissioner, you asked me during the hearing to confirm the weighting that I'd given to the Ngāmutu Central City strategy. I replied at the time that the strategy, in my view, or recollection, hadn't gone through a special consultative procedure under the LGA. But it should still nevertheless be given considerable weight and substance within your deliberations. I just wish to confirm that view. It hasn't gone through a special consultative procedure, but what it has done is gone through quite extensive consultation and workshops over a considerable 2-year period. The need and the foundation for the strategy emerged through the New Plymouth District Blueprint in 2015. Under one of the key directions of Central City championing a thriving Central City for all. The strategy was also established through the CBD 2050 Summit held in 2019 in conjunction with all stakeholders with an interest in the Central City. It was adopted in 2021, and the purpose of the strategy sets out the direction for New Plymouth's city centre through to 2050. And Ms O'Brien's provided quite a bit of information on the centres, section 42 evidence she's already provided through to you. Importantly, in terms of the evidence provided by Hapu for the Blue Haven proposal, the Ngāmutu strategy was developed in partnership with the Ngāti Taiwhiti Hapu as mana whenua for the Central City. So that's a different Hapu. This included representation from that Hapu and the project team, along with representatives from Te Atiawa Trust. And a cultural value statement was developed, which is a key foundation document that underpins that strategy. So the PDP advances a well-established and consulted on policy framework originating from the New Plymouth District Plan Blueprint in 2015, through to the centre's hierarchy concept as first introduced and released for public comment in the draft district plan in October 2016, as inclusive of the centre's hierarchy and also the primacy of the Central City. This approach reflects years of extensive public consultation, and to be clear, it was not and is not a response to the Blue Haven development. Mr York's assertion that he was not aware of the centre's hierarchy at the time of applying for the consent, which was applied for in 2018, is surprising. For completeness, the long-term plan ascribes 1.3 million to the Waiwakaio pedestrian bridge. There is at this stage no site location nor indeed consents. The premise of that bridge does not change my view that the amending proposal remains vehicle orientated with no or little proximate residential catchment and has limited opportunities for access by active modes. Are there any questions? That finishes that section. Are there any questions arising from the non-statutory document component?
How you going, Kit? Anything for you?
No, if I've got something to say, I'll interrupt.
Okay.
How about that?
Thank you, sir. In terms of the NPSUD, there was quite a bit that was traversed during the hearing, and there are a number of differing opinions as to the implications for the application of the NPSUD, particularly as it relates to retail distributional effects and consequences for the city centre zone in considering a well-functioning urban environment. Mr. Thompson's evidence was that there was insufficient capacity to accommodate necessary business land in the absence of the Blue Haven site to provide sufficient development capacity to meet demand. Now, my chief criticism throughout Mr. Thompson's evidence, clearly it's not economic criticism, is that it was not framed within the respective statutory framework provided by the Resource Management Act and the proposed New Plymouth District Plan. I consider also Mr. Thompson's analysis and reliance on guidance provided in relation to the superseded NPS UDC to be unreliable. At a localised level, Mr. Thompson asserts in support of his claim that there's no capacity within the New Plymouth CBD to accommodate the needs of LFR businesses, and he's got figure 2 within his evidence if you've got it there, but basically states that for all of these activities, a number of which are not provided for within the New Plymouth retail catchment, not only is there no space for them, but the plan actually makes those activities non-complying within the Central City district, sorry, the CBD. Now, I've replicated that, and I've stated at the outset that it's factually wrong. I'll just quickly go through each of those activities in turn. So that's figure 2 from Mr. Thompson's evidence. The first one was Bunnings, which is a commercial service activity trade supplier. It's already present within the district. Its status in the Central City zone is discretionary. It is permitted in the mixed use zone, which obviously runs proximate to and adjoins quite a substantial area around the Central City zone. The second was Kmart, which is a retail activity and a large format retail. It is not provided for within the New Plymouth district. It is permitted within the Central City zone, and it is non-complying within the mixed use zone. Mitre 10, again a trade supplier, is provided for is already present within New Plymouth district. It's discretionary within the Central City zone, and it's permitted within the mixed use zone. Spotlight, again a large format retail provider, exists within New Plymouth. It's permitted within the Central City zone. It's non-complying within the mixed use zone. The warehouse, present within New Plymouth, permitted within the Central City zone, and is non-complying within the mixed use zone. Crackerjack, and I must admit I had to look that one up, is a large format retail activity, not present within New Plymouth, permitted within the Central City zone, and non-complying within the mixed use zone. And lastly, Pack and Save and New World, which are supermarkets, are permitted both in the Central City zone and also in the adjoining mixed use zone. So Mr. Thompson's assertion that those activities, that the plan turns their face against those activities within the Central City zone and the adjoining mixed use zone is categorically false. I concur with Mr. Heath's view that there is sufficient business development capacity in the PDP as notified, and that the scale and provision of Blue Haven as a commercial zoned entity is not necessary to enable the council to meet its obligations under the NPSUD. And I think, sir, in relation to Commissioner Littlejohn's discussions with Mr. Heath, as a plan should be forward-facing and should be able to accommodate, I guess, the highs and lows when you get a COVID or as we had in Christchurch, earthquakes and various other things. That capacity analysis, I understand, was done on the growth projections of the time pre-COVID, and identified that there was sufficient capacity in terms of meeting New Plymouth's development capacity needs under the NPSUD, absent of Blue Haven. Of course, Blue Haven assists in terms of that supply under policy 2 of the NPS, but it is not necessary in terms of providing for it, nor would I suggest that a smaller or more constrained commercial yield on Blue Haven would also be inconsistent to policy 2 in terms of the NPS.
Ned, I recall Mr. Thompson's evidence was really around, he had a different interpretation of available commercial land being clear site level,
And a grade.
ground level at grade. So what do you? So what's your position on that?
Look, I don't agree. The starting point for that position was the NPS UDC and a guidance document with the NPS UDC. Obviously, it's a question for the economist to answer in full. There's quite a bit of development work in terms of going into looking at what is available capacity, and vacant available capacity is obviously the easier one to sort of take over. I do note, however, from Mr. Thompson's evidence that he identified that there are a number of earthquake-prone buildings, and the suggestion appeared to be that you just move on from those. They don't provide capacity. You don't look at sort of the ability through, I guess, a compressed centres-based model in terms of utilising those spaces and reinvesting them in a more efficient manner. And I would suggest that the policy construct within the New Plymouth proposed plan takes that into account. It essentially says that, as I understand it, and from the HBA that Mr. Heath has put together, that there are some clearly easier sites, vacant and in grade as some of those, but you don't stop there. You also look at whether or not areas can be used more intensively or more appropriately, and there are assumptions as to the provision of those to absorb capacity over time. Does that assist?
Yes, thank you.
I just wish to say that Mr. Heath's evidence on this matter has been consistent throughout the preparation of evidence and hearings on all chapters of the proposed district plan. And as you've just heard from Mr. Heath, it also reflects many years of economic analysis of the New Plymouth district market. Now, a number of Mr. Thompson's responses to the panel's questions challenged the centres-based approach at a more fundamental level, rather than just outside the amending proposal for hearing 22. His stated preference for a less interventionist approach appeared to be based on the view that such would assure the delivery of economic efficiency, but also traversed well outside even the scope of the BCL submission. Ms. Barry Pacino takes the statement further, positing at 7.9 and 7.17 respectively of her submissions. Mr. Thompson's opinion is that the analysis undertaken by Mr. Heath is insufficiently robust to provide empirical support for a hierarchical approach. Mr. Thompson's retail gravity model is robust, forecast evidence to rely on as to the effects over the next 10 years. Nor has evidence been provided to justify a policy position that any issues with the CBD's vitality might be resolved by intervention with the Blue Haven Centre. Now, the BCL submission did not seek to fundamentally alter the strategic direction objectives in terms of section 32(1)A. That was covered off in my brief overview. Mr. Thompson has not provided any consideration at all in terms of section 7B of the Act that directs decision makers to have particular regard to the efficient use and development of natural and physical resources, which would include the city centre and urban form and growth relationships to residential areas and infrastructure integration. Nor has he considered the wider aspects of well-being and the definition of sustainable management in section 5 as inclusive of the economic well-being for people and, more importantly, communities. Now, the PDP approach seeks to implement a centres-based hierarchical approach. Categorically, it is market intervention. However, as established by the section 32 evidence accompanying the proposed plan and the extensive analysis provided by Mr. Heath, the centres and hierarchy approach concerns what is in the best interests of that community, especially given a comparison to the operative plan provisions, which provided for the consenting of the development of at BCL, without any recourse to any consideration of retail distributional effects. I do not support the statement by Mr. Thompson and echoed by Ms. Barry Pacino that Mr. Heath has not assessed the economic implications of the amending proposal, including the broader centre hierarchy implications. As identified by Mr. Heath, both the section 32 report accompanying the notified PDP and the subsequent evidence preparation, including that associated with the hearing 22 matters, are predicated on detailed retail market research that inform the centres-based approach of the notified plan, dating back some 6 years and is accompanied by repeated ground truthing. It still remains unclear to me as to whether Mr. Thompson has surveyed the central city during proceedings. Simply, Ms. Barry Pacino's statements at 7.9 and 7.17, I would suggest, are wrong. Any test for a less restrictive consenting regime, non-centre development must be contextually based. To compare annual accumulated household growth and spending power in Auckland, circa some 13,000 households per annum, with nominal growth in New Plymouth District, some 300 households per annum, and therefore the ability to overcome through growth, reductions in sales in centre as a consequence of out-of-centre development is, in my view, misleading, but is the basis of a number of statements made by Mr. Thompson. I would also level that criticism at the material provided by Mr. York in relation to the base in Hamilton and the evidence of Mr. Batchelor with regard to Tauranga. And Mr. Heath covered off that material as well. Also, Mr. Thompson referenced the UK sequential test and also the Auckland Unitary Hearings Plan process. I just put that I've worked under both. And was actually the reporting officer for Auckland Council in terms of those hearing topics. The only point that I can make is that either of those references are entirely irrelevant to the matters before this panel. Putting aside my concerns over the evidence presented by Blue Haven, I would like to qualify that under the NPSUD, planning decisions must do more than simply add to development capacity. Under Policy 2 and Policy 6, they must also contribute to well-functioning urban environments. Now, I accept that the codifying of the resource consent to the Blue Haven site will enable some elements of well-functioning urban environment on its own site, provided that there is surety in terms of the design outcomes and the expression of cultural traditions and the reconciliation of transport infrastructure with land use. Now, there's very little light in the commercial zone recommendation and also the special purpose recommendation provided by Mr. Brophy in relation to those specific matters. The NPSUD does not provide for the segregation of component parts of an urban area. Now, I reach that view based on the definition of urban environments, and that Policy 1 seeks that planning decisions contribute to well-functioning urban environments. Therefore, there's a need to look broader. Now, away from its own site, and given the requirements of the NPSUD is focused on New Zealand's urban environments as a whole, the retail distributional effects Mr. Heath anticipates at the New Plymouth Central City Zone would cause that centre to decline in functionality, role and purpose. The amending proposal also represents limited accessibility in terms of public and active transport and does not support reductions in greenhouse gas emissions. Now, in terms of the latter, I note Mr. Brown's commentary as to the uptake in EVs offsetting these costs, but I consider that no substantive evidence was provided to substantiate or quantify those trends, and regardless, any shifts would be derived absent of the amending proposal. There's quite a bit of questioning about the gravity model and produced by Mr. Thompson and the analysis undertaken by Mr. Heath. In my view, there's a lot of noise. I think there's some fundamental matters in terms of the panel's decision or determination as to, is there a significant adverse effect from the amending proposal or not? I'm not an economist, I've made that abundantly clear, and also in terms of questions that I've worked around as asked by the panel. But the fundamental issue for me in looking through the evidence really comes down to this diversion of sales figure from the central city, and also what is the central city agreed retail spend. Now, I understand that the basis of Mr. Thompson's view that overall effects will be insignificant, and effectively I understand that means they're almost indistinguishable, is that his retail gravity model identifies that Blue Haven will divert 105 million per annum of total city centre spend out of 475 million annual New Plymouth Central area sales. 475 million is based on Mr. Heath's 2023 annual sales figures. Now, I simply cannot agree that a sales diversion of 20%, that is $1 in every 5 being spent currently in the CBD, being diverted to Blue Haven, could credibly be suggested to result in insignificant effects. This is even before the vulnerability of the centre from which diverted spend is accounted for. This is the point that Mr. Heath was identifying in terms of the tests in front of the panel for looking at distributional effects. You can't stop at just looking at diverted sales. That's your starting point. You've then got to look down and say, well, if we remove that extent of diverted sales, what does that do to the centre that we're examining? And that requires a consideration of the social and functional amenity of that centre, its role and function in terms of a hierarchy, how vulnerable is that centre to increased trade diversion. A very robust centre in a market where there's considerable household growth will be able to withstand substantially diverted spend of even relatively high numbers. That was the process we worked through in Auckland. This is not, as I would suggest, the case that we have in New Plymouth. We have, as been identified through various strategies, a vulnerable central city that the council itself is looking at investing considerable further public investment in. The survey data by Mr. Heath identifies that there's a considerable proportion, well over 10% in terms of vacancies. It's a vulnerable centre. So simply in my view, it is not credible for Mr. Thompson to suggest that a 20% diversion results in an insignificant effect. And that's even prior to actually looking at what state the central city's in. Mr. Heath provided factual and survey-based information as to the vulnerability of that central city, and said as a consequence that the effects will be both significant and enduring from the amending proposal. Now, as I've identified, I'm not an economist, but I don't need a model to be able to, from those very basic facts, identify that there's an issue. And that is why I've concurred with Mr. Heath and continue to do so, that those effects will be significant and enduring. Accordingly, I do not accept the Blue Havens amending proposal would uniformly contribute to a well-functioning urban environment for the purpose of giving effect to Policy 1 of the NPSUD. Ms. Barry Pacino also stated in legal submissions at her paragraph 7.14 to the panel that if the New Plymouth CBD is at such risk as suggested by Mr. Heath for the establishment of the Blue Haven Centre, then the appropriate response is for more investment interventions from council to stimulate development potential, such as addressing deficiencies in the CBD attributes, such as infrastructure upgrades and physical environmental improvements. Now, firstly, such an approach would derogate from the council's responsibilities under the Act. And as stated above, the policy thrust in the proposed plan, which is both directive and deliberate, is moving away from a more dispersed approach to commercial development that was provided for under the operative plan. Secondly, the council, through its Ngāmutu Central City strategy and the LTP, identified non-statutory mechanisms to lift the CBD, including considerable spend. These statutory and non-statutory processes are to work in tandem. Now, in making a planning decision that would affect urban environments and determining that the general industrial zone as notified is not the most appropriate, in my view, the panel would need to firstly conclude that the Blue Haven consent had been given effect to, and I think we all agree that that's the case, and subsequently be likely to be implemented. And hence the economic implications of the scale of retail diversion have altered the basis of the review of the district plan to the point where something between the notified plan and the amending proposal was the more appropriate in terms of section 32AA. Secondly, the panel would need to be assured that it can ensure that activities are constrained and codified such that the scale and extent of distributional effects on the central city did not extend beyond those provided for by the consent. Now, in my view, there is no or little evidence before the panel in terms of section 32AA that transport and economic matters would otherwise achieve sustainable management. The associated provisions established in the evidence of Mr. Brophy, I would suggest, provides a policy approach that facilitates without any realistic constraint, additional capacity, and a restricted discretionary activity status that would achieve the same. And I note in Mr. Brophy's Appendix B, the special purpose policy 3, which talks about having to regard for additional growth as to whether or not the activity will have an acceptable effect on the compactness, dynamism and vibrancy of the central city zone, which I would suggest is probably less than appropriate in terms of being directive as to providing a constraint. And that would be in addition to restricted discretionary matters, and Mr. Littlejohn referred to those today in his discussion with Mr. Heath about adverse effects on the viability of the city centre zone and whether or not there was feasible ground floor net floor area in the city and town centre zone for the proposed activity. I would suggest that those matters fall well short of constraining activities appropriately. So in terms of the NPS UD Policy 6, which directs decision makers have particular regard to planned urban form, a changing urban environment and the benefits of a well-functioning urban environment, I note going through each clause. For subclause A, the PDP and notified general industrial zone did not anticipate the planned urban development proposed by the amending proposal, and as identified by Mr. Heath, sufficient business development capacity is provided in the absence of that relief. Subject to subclause B, is subject to either the consent or design provisions under either recommended approach by Mr. Brophy or myself, amenity in this area would be improved. In terms of subclause C, this matter arose in questioning between Commissioner Littlejohn and Mr. Batchelor as to the interplay between a decision under Policy 1 and therefore given benefits in terms of this clause, would there without further need for deliberation in terms of subclause 6C. Now, I've reached an alternative view to Mr. Batchelor, included as a basis, is based on the retail distribution impacts on the city centre, that the relief will not contribute to a well-functioning urban environment. Hence, there is a need for the panel to assess and weigh up Policy 6C within their deliberations. In terms of subclause D, I've concluded that the Blue Haven relief will contribute to development capacity, but it is not essential for that purpose. In terms of subclause E, given the peripheral location of the amending proposal and reliance on private vehicle trips, that there will be an adverse effect on climate change because of transport emissions. Lastly, a recommendation by the panel to recognise the amending proposal as a centre results, in my view, in consequences as to the application of Objective 3, requiring enablement of more businesses and community services to be located in an urban environment, the area where that area is within a city centre zone. And I discussed that, Commissioner Littlejohn, with you at the hearing, and I still hold that view. So in terms of allocation and protection, just briefly, Blue Haven's proposed sub-regional centre zone would be subsumed into the hierarchy of centres. This confers an allocative under UFD 16 and a protection under UFD 18 strategic policy response. Ms. Barry Pacino's submissions do not deal with this matter, but in dialogue with the panel, she expressed a view that UFD 18 should provide protection for Blue Haven. In addition, Mr. York expressed the view that factually this is a centre if it walks like a duck and quacks like a duck. Mr. Batchelor also answered in response to a question as to what recognition of the Blue Haven Centre would provide. The ones that are identified, they are valued. If someone wants to establish an additional centre, then you'd have to look at the impacts on Blue Haven. Now, the proposition from Mr. York, Mr. Batchelor and Ms. Barry Pacino is that if it is defined as a centre, the BCL amending proposal should automatically have status under UFD 18 and therefore be accounted for in any determination of non-centre adverse distributional effects. UFD 18, in my view, is clear. It is to ensure that business activities in non-centres, which would extend to the MUZ and large format zone, do not undermine the role and function of the district centres and or hierarchy of centres. Now, the hierarchy versus network submission point from BCL does not alter that policy direction. UFD 18 does not provide for consideration of adverse distributional effects between centres. That is, the implication of a retail expansion of a centre at a lower scale on the hierarchy on a higher order centre is not accommodated within that objective. So in terms of a real world analysis, expansion of a local and town centre network is largely to be precluded by zoning, scale and site configuration. The exception would be the BCL amending proposal. Now, the evidence from Mr. Heath is that the BCL consent would result in significant adverse effects on the role and function of the city centre zone. He subsequently concludes, I do not consider any expansion above the existing land use land use consent of retail and commercial office and accommodation activities appropriate for the Blue Haven site. If the intention of UFD 18 is to protect the existing centres network from demonstrable adverse distributional effects, then it would be illogical within UFD 18 to exclude a consideration of the amending proposal on centres within the hierarchy, given, as based on the evidence of Mr. Heath, that such would extend to the extent of significant distributional effects on the central city zone. And both the council and BCL recommended zoning options to varying degrees require consideration of the impacts on the central city zone from expanded retail and office floor space. Now, in terms of Mr. York's assertion that the Blue Haven site is a centre, with respect, it is only represented by a consent, and as identified below, there are concerns raised by the BCL witnesses during the hearing as to providing flexibility in terms of likely implementation. Physical resources represented by the Blue Haven consent is currently given effect to are narrowed to a rehabilitated site. Infrastructure upgrades to the transport network have not occurred, nor are there buildings or amenities that would provide for social and functional amenity to the community. Now, this does not derogate from the very substantial investment by BCL, but it is to be seen in the same context as any private investment reliant on a resource consent. The investment has not, as yet, resulted in social or functional amenity benefits for the community. The developer can rely on and obtain planning certainty from their consent. By contrast, the physical resources represented by the new Plymouth City Centre as an agglomeration of substantial private and public investment and its associated social and functional amenity should be accounted for in terms of risk posed by the amending proposal, and therefore any subsequent expansions in terms of significant and enduring adverse effects, as outlined in the evidence of Mr. Heath. It would be premature, in my view, in the absence of considerable advance in terms of built form on the BCL site, to support a policy regime that would seek to protect the BCL site from adverse distributional effects. As stated in the hearing, it would be a perverse outcome in seeking a section 104(1)(b) consent to preclude a non-centre based proposition where such sought to establish in the MUZ adjoining the central city on the basis that it should more appropriately be located at the BCL site. I retain my view that the BCL proposition is not a centre and should not be added to the hierarchy or network of centres, and subsequently both the allocative and protectionist elements of UFD 18. Lastly, I reject Ms. Barry Pacino's criticism the Council's approach focuses on the effects of the CBD rather than the benefits accrued from the amending proposal. And I simply point the panel to paragraph 195 of my evidence in chief in that regard. Now, the evidence of Mr. Heath is unambiguous that the amending proposal will result in a net reduction in economic performance of the central city zone. In terms of the discussion around hierarchy versus network of centres, and I think this is possibly important in terms of the interim guidance that the panel provided, and I understand the directions that will be given next. I agree with the recommendations and evidence provided by Ms. O'Byrne on this matter. She notes that reference to network would imply that centres have more of an equal role and function, which is incorrect given the interdependence between each tier of centre and its associated community requirements. Now, I consider that the hierarchical design and associated centre-based approach stated in UFD 16, 17 and 18 is the more appropriate in terms of achieving the purpose of the Act. Giving priority to the central city, then relative priority to town centres and lastly local centres is simply the logical and factual recognition of the agglomeration of societal and economic well-being and physical resources represented by each tier of centre. The benefits to the community in taking a hierarchical view associated with centres in the district plan includes policy recognition of greater amenity benefits in terms of recognising the function between spatial scale, outcomes, vitality and vibrancy of centres, agglomeration benefits, such as increased specialisation within centres and economies of scale with consequent productivity gains, better transportation and land use efficiencies, and increased scales, and with at increased scales, The location in centres of retail activities and community facilities, such as libraries, means increased accessibility to these facilities for the greater social wellbeing of communities. All of these attributes are represented in the centre's hierarchy, and Plan Express policy and regulatory bias linked with each centre in that hierarchy, in both the enablement and protection sense for specified centres, but then more importantly in the architecture of the plan, how those things are then reflected in the zoning and activity classifications and standards and other matters. Such statutory recognition is not narrowed solely to retail spend, but more importantly in terms of the spatial patterns associated with urban form and growth. It was conceded by both Ms. Barry Pacino and Mr. Brophy that the city centre has primacy amongst centres and is settled within CCZ 01. The confirmation, in my view, acknowledges a centre's hierarchy. Lastly, I refute the assertion by Blue Haven's witnesses that the centre's hierarchy approach taken in the PDP was in response to the Blue Haven proposal. The centre's hierarchy was signposted in the district blueprint in 2015 and explicitly identified in the draft district plan in 2016. The application for the Blue Haven development was dated December 2018. In terms of a sub-regional centre versus commercial zone, if the panel determines after weighing up all the evidence that a commercial orientated zone is preferred compared to reliance on the resource consent and the notified GIS zoning, I consider that a codified and constrained commercial zone is the more appropriate. I consider that centres within the hierarchy play an important community role, particularly in terms of providing community facilities and public assets. Centres are not just for commercial activity, they service an important wider community purpose and have a symbiotic relationship to established residential communities. For the central city zone and town centre zones, this extends to providing a focus for higher density living environments and integration with modal and active transport options, as was identified in the evidence of Mr. Campbell. By comparison, the BCL amending proposal was retail orientated, devoid of public investment or community activities, and has limited to no adjacent residential catchment. I retain the view that a centre zoning would be premature in terms of the application of the amending proposal. In terms of likely to be implemented and then reasonably practicable options, the Section 42A report outlines the reasonably practicable options associated with the amending proposal. As predicated solely on the consent, the report recommends a commercial zone and associated provisions as set out in Appendix 2 to that Section 42A report. And I'll just briefly read that out. If the context of the submission request did not contain the implemented consent, I would be recommending that the amending proposal be rejected. In a similar manner, if the panel, upon hearing all the evidence, concludes that the consent should not be given as much weight as I have, the retention of the GIS as notified remains the most appropriate option. I maintain that recommendation. The Section 42 report identifies an alternative commercial zone recommendation based on the consent, whilst given effect to and able to be considered as part of the environment, but isn't determinative as to the appropriateness of the amending proposal. But if the economic implications as consented are sunk costs, a tightly constrained suite of provisions would manage as much as possible the level of development within the wider strategic framework of the plan. The extent of misalignment between the BCL amending proposal and the proposed plan approach to commercial distribution, that is, the relief as identified by Mr. Heath, would result in significant adverse effects on the central city. And lastly, the consent should not be used as a springboard for further commercial activity, nor the diversification or increase in activities not otherwise consented, or where such would duplicate the role and function of the city centre. And you'll see within my recommended provisions, a harder line or a higher activity threshold is provided for in terms of those community facilities than in Mr. Brophy's. The BCL submission states that the GIS is not appropriate for the site at 662 Devon Road on the basis that the consent was lodged and subsequently granted, providing for commercial and retail activities, recontouring the PAR, and associated upgrades to the supporting road network. The analysis provided in the Section 42A report recommending a commercial zone is predicated on the basis that the consent is likely to be implemented. And indeed, the floor space thresholds recommended within the provisions by both Mr. Brophy and myself are based on those consent thresholds. However, during the hearing, in response to panel questions from Ms. Barry Pacino, Mr. York and Mr. Batchelor, it became increasingly apparent that what was actually being sought is a far more enabling and flexible suite of plan provisions so as to respond to market demand, which, as identified by Mr. York, has moved on subsequently to the consent being issued. Now, the problem with that approach goes to the heart of the following matters. One, is the consent therefore actually likely to be implemented? And if not, what is the more appropriate framework to consider changes, section 127 versus the amending proposal? Two, does the BCL submission scope provide for enablement beyond activities expressly provided for by the consent? And three, what is the section 32 AA evidence burden necessary to provide for enablement beyond activities expressly provided for by that consent? So turning to that first one, is the consent therefore likely to be implemented? Ms. Barry Pacino identifies that the details of the hotel may need to be reconsidered, and in response to panel questions, identified the sub-regional zoning requested is to provide flexibility to Blue Haven moving forward. Mr. York, in response to questions, identified that increased flexibility is needed beyond the consent to enable changes over time. And Mr. Batchelor responded to questions that it is highly likely the consent will need to be varied as the site is developed. In my view, this moves well beyond codifying the consent. The approach taken in my evidence was that increased certainty could be provided through a tightly constrained zone, the basis of which would facilitate incremental change through the detailed design process without reliance on a section 127 process, effectively increasing efficiency and effectiveness for the landowner and developer of managing the consented environment outcomes under the district plan regime, effectively to provide a codified consent in a zone to integrate in with the district plan and ensure that everyone in the community was aware of what the outcomes therein would be. Now, BCL's witnesses and counsel have expressed a view that development as consented is unlikely to now proceed as pursuant to that consent. This, in my view, reduces confidence and weight that the panel should place on whether the consent would likely be implemented. Accordingly, the purpose of the Act may be better served through careful consideration of any amendments through a section 127 process as benchmarked against the general industrial zone. In terms of the last point, what is the section 32 AA evidence burden necessary? The expert evidence provided to the panel is reliant on the activities and effects enabled by the resource consent. In terms of economic effects, I consider the evidence of Mr. Thompson falls well short of providing a robust analysis of the consent, amending proposal, or enablement of any floor space expansion. I've already identified the concerns that I have with the recommended special purpose regional centre objectives, policies and rules and matters of discretion identified by Mr. Brophy. I would consider those provisions as a suite far more enabling than what's been recommended within the commercial zone. I consider the burden of providing for such an enabling suite of provisions has not been established. This is especially as measured against the backdrop of analysis provided by Mr. Heath. As also identified by Ms. Wallace in reading out the evidence of, the verbal reply of Ms. Taylor, the transport analysis identifies the upgrades necessary to accommodate the consent and would resolve those issues. But that there would not actually be additional capacity provided within the network to easily accommodate additional floor space under a more enabling zone. Lastly, in terms of tangata whenua issues, I'm almost there. The evidence provided by Ngā Mata Skipper was compelling, fundamentally seeking improved environmental outcomes within the Rohe, extending well beyond the Blue Haven site. That evidence is acknowledged. The benefits and collaborative approach between the Hapu and BCL is commendable and is enshrined within the consent. And also I understand the MOU between the parties. I note that I haven't read or haven't got a copy of that document. The recommended frameworks provided by myself and Mr. Brophy seek to further enshrine that relationship. However, it is noted that Ms. Marco has identified further improvements. Ngā Mata Skipper also acknowledged that an MOU is not a contract and that she wanted to ensure that any planning framework had all the hooks to ensure Hapu have a voice heard going forward. Responding to questions from the panel, Ngā Mata Skipper stated that the GIS zoning extending beyond the Blue Haven site was less appropriate in terms of cultural values, and furthermore that a substantial commercial centre associated with the BCL proposal would appropriately draw activity towards their rohe. Now, in terms of this latter matter, the primacy of the central city is a key part of the proposed plan. Its value, significance, and ongoing vitality and viability was also established through the Ngā Mutu Centre City strategy, as developed in conjunction with Ngāti Tai Whitu Hipahapu, who have mana whenua for the central city. And I also note that Ms. Marco was a little more balanced in terms of the recommendations she provided to the panel, in terms of considering the values of the central city when looking at opportunities for greater enlargement and enablement associated with the amending proposal. Lastly, in terms of an amended set of provisions, a number of useful suggestions were made in the evidence of Ms. Heppelthwaite, Ms. Marco, Mr. Brophy, and also through discussions with Commissioner Littlejohn as to a more directive policy in terms of retail floor space, the recommended commercial zone policy 3, also the issue of residential units. The nature of status and was a non-complying status the more appropriate for enlargement was also raised by both Mr. Campbell and Ms. Marco. Based on that evidence, I tend to provide through formal written reply process an amended suite of provisions as associated with the commercial zone that was identified within the Section 42A report. Thank you very much for your patience. That was extremely long-winded, but I appreciate the opportunity to provide it all.
Just on that last point, Matt, can you signal where you're going to be landing in these revised provisions around the non-complying?
Yes.
RDA?
The
additional area?
Yeah, the question I'm struggling with at the moment in terms of how to resolve that particular issue, again, comes back to the complexity of the resource consent, which is a live matter, and I understand hasn't been given up by BCL. So the question then becomes, if the status becomes non-compliant, could the landowner actually fall back to the discretionary status provided for in terms of the Section 127 consent? And I haven't quite landed in terms of where I sit in terms of where that threshold is. At the moment, if you recall, within the commercial zone recommendations, I've recommended a combination of largely discretionary, but there is the odd non-complying activity for all those, the concerning activities being sort of commercial office and retail activities. Where I have landed, and I can signal this, is after the discussion with Commissioner Littlejohn, I went back and looked at my provisions and also the provisions in Mr. Brophy's evidence, and his he did some amendments to my recommended commercial zone provisions. I'd note within those, it's not clear, or at least it doesn't appear that he struck out amended text. There just appears to be new inserted text. So it was difficult to sort of catch up with those. But I would suggest that Mr. Brophy's provisions in both his recommended provisions and against mine would effectively look at weakening the policy construct in terms of constraining activities. And in a very quick answer to your question, I've looked at putting in an avoidance policy effectively around the floor space caps within the commercial zone provision. So I will be recommending that to the panel. Essentially under, I think it's Commercial Zone Policy 3, which is in the sort of architecture of the New Plymouth Plan. There's a provide for, manage and avoid. There'll be an avoidance suite of provisions linking back to the floor space thresholds that have been provided for via the consent. And I think that either a discretionary or non-complying activity status, having that policy construct there, I think, is probably the more critical.
Okay, I see, Kit, you're off. Is there something you'd like to?
Yeah, no, I just wanted to say thanks for that, Matt. That was incredibly thorough. And
hopefully that wasn't a euphemism, sir. But I appreciate it.
No, not at all, not at all. It's always good to have other people who were in the room, were listening to the same things, have an opportunity to think about it and sort of gather their thoughts. And to some extent, I think we've had the advantage of a couple of weeks of that sort of gestation, because certainly it's it hasn't sort of left my mind as to what's the answer here. So I very much appreciate your input on that.
I will provide those as a written copy within the next couple of days for all parties, including the panel.
Yeah, I have to say at one point during your address, I was going to pipe up and ask, so are you recommending we just go back to the GIZ zone? Because it did sound very much like you were tending in that direction. But I think you pitched it to us as I think you began, which is if you come to a different view on the weight that this thing ought to have, then that really to some extent will determine where you end up. And
Yes.
And I think that's probably a sensible way for us to have a look at it.
I think that's correct. And look, categorically, and as I've said, without the consent, it would be a very plain recommendation from me. And I think I've made that abundantly clear. It really comes down to this legal test and the panel's determination with all the matters in front of it, including that provided by Mr. York in terms of, look, they have spent substantial money on the site. Is it actually likely? And I came through the joint witness process, and I think it was the same in terms of the economists and especially the transport witnesses, that essentially what was being sought was largely codifying the consent. So as I've identified here, and as I should, it was of some surprise during the hearing process to hear the experts and counsel for BCL effectively saying, oh, look, now that we've got this far, actually what we're wanting is something far more flexible. And to me, I think that really does go back to two issues before the panel. Fundamentally, are you convinced that it is likely to be implemented? Because I think there's quite a substantial question mark there now. And secondly, if you get over that threshold, what is the Section 32 AA basis for you in terms of looking at the suite of provisions and the options you have between myself and Mr. Brophy, and saying, have we actually got any evidence that allows us to provide either a very, I would respectfully use the word, enabling special purpose regional centre zone compared to something that's a bit more constrained? And I've gone back and reflected on mine on the basis of the discussion that you and I had and said, actually, I probably haven't been constrained or constraining enough. So I think you've got those two thresholds that you need to get over, if that's the help.
Yeah, no, it is. It's it very much does crystallise it all. Yeah, the interesting the interesting thing going forward is, and I think you made the point about whether you leave it as a consent and allow it to I guess stretch and modify itself using 127, or do you, and in which case it sort of takes the default discretionary status, albeit that the objectives and policies of the plan as they exist at the date of that variation application would be brought to bear on it under a 104 approach. But of course, you lose the protection of that the moment you sort of go outside the scope of a variation to some extent. And so that's when your underlying zone provisions would kick in effectively, wouldn't they?
Yeah, correct. Yes. I mean, the intention was, and again, it was a very useful and positive exercise going through the joint witnessing process. There are a number of matters where, where lines are drawn on a map and you go through detailed design where, I've been in this business for some time, you expect some tweaking.
Yep.
And everyone should have some certainty, including obviously the developer and the wider community, as to the scale and range of what that tweaking would be. It simply improves efficiency and effectiveness.
Yep.
However, there becomes a point where that band effectively starts to break, where the zoning that you provide for doesn't in the end reflect what the consent was, or is simply too enabling as a consequence.
Okay. All right. No, that's all very helpful. I didn't have any other matters I wanted to flesh out with you. I look forward to reading your comments again too, and looking at your revised provisions.
Thank you.
Yes, Matt, I just have one clarification for myself. You talked about UK sequential test and the Auckland unitary plan experience. You said that
Yes.
both of these are irrelevant. That is because of scale and context.
Oh, just
comparison.
I could pick a starting point. Essentially, they both put into play substantially different policy architecture and structures to deal with household population and business growth that bear no resemblance at all to the issue that's in front of the panel. They're separate as night and day, apart from the fact that they deal with retail distribution. It's kind of the start and finish of it. It's simply unpalatable, I would suggest, to identify that the panel should take some direction from something that's done in a policy document in the UK. And I left there in '99, and it was irrelevant to New Zealand then, and it's irrelevant to New Zealand now. And in Auckland, as I've identified, 13,000 households per year tends to mask quite a bit of distributional activity, which was the basis for why that joint witness statement between the economists was drafted. I don't think you can lift that up in economic evidence and provide that in a different setting and say, well, we all agreed to it here, so we should agree to it in this particular instance. I think that's improper, but I'll leave it there.
Okay, thank you. Look, there's two things I'd like to do. I'd like to just get some brief verbal submissions from both Lauren and Kate about where we're at with the economic evidence, given the position that was in the joint witness statement about, yes, there could be some further economic assessment done if there was sufficient time and resources, and whether there's any merit in that, or have we just be flogging a dead horse. So I'd like to hear from both of you just briefly on that point. Secondly, I'd like to take a break and talk to Kit about our next steps before we come back to you. I think it's about a 15-minute discussion. So let's just take those two things in order before we do that. So,
would you like me to start?
Yes, please, yes.
Whether there's any benefit in the economists getting back together. Look, I think, so as I understand it, essentially the most determinative finding that they've both come to is this 105 million versus 120 million.
Yes.
Mr. Thompson's evidence, as I understand it, is that will be insignificant, and Mr. Heath's evidence is that it will be significant.
Yes.
There's only a $15 million difference there, so it seems to me that there are some. I'm not sure how much going back together will really achieve, given that stark contrast in their opinions on the end result. So whatever the inputs are, they've both come up with quite a similar figure in terms of the effects on the CBD. One's view is that it's insignificant and one's view is that it's significant. And as I understand it as well, the basis for that is the starting point, which is that Mr. Heath or Mr. Thompson is of the view that the CBD is reasonably healthy and is doing fine, and Mr. Heath's view is that it's not. I just wonder whether perhaps a third, I hate to suggest it, economist's opinion on, what's your view if you take out, let's take the average of 105 and 120, what's your view of the impact of that on the CBD? But, I'm conscious of time also.
Yes, okay. Thank you. Kate, what's your position on this?
I think that the differences between Mr. Heath and Mr. Thompson, with all due respect, are broader than just a numerical number. I think what you saw in the response from Mr. Heath today suggests a level of, shall we say politely, some strong personal differences that seem to be displaying themselves in how the two experts are countering each other with differences of opinion, which doesn't suggest to me that it's going to be productive to have the two in the room in terms of being able to be objective, because I think it appears to me that there's some of that has definitely been lost. And I don't know if it's pre this hearing or just through it. The second thing that appeared apparent is that Mr. Heath focuses on other aspects under the RMA that he considers as an economist that he should include in his evidence relating to, for example, I think cultural, social. He sort of references those words in the broader RMA, whereas it appears to me Mr. Thompson is very much more purely focused on economics and economic analysis from a data-driven sense, and leaves those other aspects to other experts within the RMA context in terms of making findings. And I think that that's quite fundamental in terms of their differences of approach as economists, and I think that's reflected too in their differences in opinions. So in my view, I can, come to the same outcome, perhaps for different reasons, that I don't think at this stage it's necessary. I think that really the plan provisions, and I think the questions that came from yourself, I think Mr. Daesh, or it might have come from Kat, apologies if I can't recall, around how will the planning provisions that are left for the RDA process or DA process, and that relates to criteria and policies, are probably going to be the most important, because I think what's been suggested by the planning approach is that there is the permitted baseline, which does reflect the codification of the consent. And then it's the next step, which is, what if you do something different? How is that shaped or formed or controlled through the planning provisions? That I think is going to be the most important, by looking at what's been set down as RDA, what's been set as DA, or is it necessary to go to non-complying, if that's something that the panel is mindful of. And in that context, what are the objectives and policies that sit behind that framework? And I don't really think the economists are going to assist in that.
Okay, thank you for that. We will take a 15-minute break back at 4:45, and Kit and I will just confer about where we go from here. There's 2 or 3 steps to set in train. We just wanted to chat that through. So we'll come back at 4:45. Thank you.
Thank you.
Thank you, Julie. I think we're back on the recording now. Look, thanks for your patience waiting for us. It was important for us to reflect as a panel on this matter about the next steps. And we have done so, and we've decided that we do need to do some further deliberations around these matters with the whole panel who are involved in the strategic objectives hearings, and also the 2 other commissioners are thoroughly involved in the commercial zones and the other matters that we have before us. So what we consider will be of most assistance at this stage is if the council section 42A reporters could complete their written right of reply, and we need to set a time frame for that. Part of this is a timing issue around availability of the panel. We've got pretty busy August with final hearings. We do need to get together after that to deliberate, and we think we're better off to just get the written right of reply on this matter back from the council staff. We'll then deliberate, and we may, through that deliberation, make some directions for some further assistance, but we may not as well, in terms of the whole set of issues that we have before us with this hearing. So that's our decision. Are there any questions, or we do need to settle some time, Lauren and Matt and council team, about bringing this together? And of course, in that section 42A report, we will be seeking your recommendations on on the provisions. And you may, like some of the 42A reporters are giving us either ors. Sounds like you might be pretty firm now, Matt, on what your direction might be, but that will be part of the report back to us in writing. So is it what's the time frame you've got in mind for the formal written right of reply?
That's a great question. We hadn't actually discussed it because we weren't entirely sure what the process was going to be after the hearing, but I would have thought 2 to 3 weeks would be sufficient, but Matt, I'm not sure what your timeframes are like.
Dance card's horrendous, but 2 to 3, yeah, if we could look at 3
2 to
weeks, that
3.
would probably give the team sufficient.
Okay, do we have someone's got a diary date for that?
So,
10.
sorry. So could I just make a comment? You know, it has been 3 weeks since the hearing, and the right of reply in terms of dates been indicated for a while. I'm surprised that nothing's been provided in writing to date. It appeared as if Mr. Bonus had quite extensive notes already. I think in fairness to ourselves, to Blue Haven, we would like to have the comments that have been made in writing actually circulated. I mean, our team, after submissions, even in oral comments, got that quickly turned around within 2 days and did so and sent that to the committee, so that even what was given verbally was sent out. And I'd like to see the same happen here, that Mr. Bonus's written comments are sent out in their current state. I'm surprised that nothing's in writing. I just would like some timeframes that are quite tight. Everyone's got tight dance cards, as Mr. Bonus says.
Yeah, hey, I think just to be clear, we're just following through the process that we've done for all of the hearings that is set out in our hearings procedures, that the 42A report people do give us a verbal right of reply at the end of the hearing. There has been, and they do this just in the same format that we've had. Sometimes when the matters are written down and clear, we've asked for the notes, and this time Matt has volunteered his, so I think there's no problem with getting those notes out in the next 2 days, Matt, from what you've given us. 3 weeks does seem quite a long time to me. We were wondering whether we could look at a 2-week time frame for the written right of reply.
Well, the only reason I suggest that is because if we're going to provide finalised recommended zoning provisions, it may just require slightly more time than 2 weeks. We could aim for the 10th of August, just 3 weeks from today's date.
Okay, but just let's set aside the timing for this. Kate, there's certainly no opportunity, in my mind anyway, for yourselves to provide anything further to us after the written right of reply unless we ask for it in direction. So I'm a bit not quite clear what the urgency from your side might be in terms of setting this time frame for the written right of reply.
So it's really just in terms of fairness and process, in that whatever's been said verbally today, if those notes can be circulated, I just want to ensure consistency with what comes out in writing, that it's not an opportunity over the next 2 or 3 weeks to develop those to another whole round of unexpected statements on evidence that have come through. That's all.
Yes.
And yeah.
Sir, I can state that we will get these documents through to everybody within the next 2 days. And the right of reply probably won't expand too much on those apart from the suite of provisions.
And that's certainly that's consistent with what we've had through the process and all the other, how many dozens of hearings we've done. So Matt, Matt and Lauren, if that's the case, there shouldn't be too many surprises. Or any surprises in terms of evolving things further. But we are, as part of that, Lauren, will be getting your further legal submissions on those matters you signalled at the front in terms of the 3 or 4 aspects as well. So look, let's stick with the 10th of August. Let's stick with, by the end of Friday, that the council team circulates the written notes to everyone involved. And next date is the 10th of August for the formal written reply from the council team. And then we'll take that into our deliberations process. And if we have further direction seeking assistance, we'll do that in due course.
Thank you, sir.
Thanks,
Thank you, Sarah.
Thank you. And we've used the afternoon up, so it's been a
I can only apologise.
no, look, these are important matters. Everyone's putting a huge amount of effort and brain power into working through a appropriate and good process here. So certainly don't apologise. And thank you for your attendance this afternoon, everyone.
Thank you. Thank you, panel.
Sarah.
Thanks, everyone.
Thanks, sir.
Bye bye.